Hey, good morning. Hope everybody's doing well. Thank you for joining us this morning. My name is Christopher Nudo. I'm an attorney in the Chicago metro area, serving all the surrounding counties of Chicago. My practice focuses with estate planning, probate, real estate law, and corporate transaction law. And I'm very happy that you would join us here today. We like to serve the community and take care of everyone to the best of our ability. We meet either in person or virtually, and so scheduling an appointment with us should be on your terms, and we do it. We make it very easy for you. Today, we're going to dive into a very important topic that is estate planning considerations for the LGBTQ community. And I want to start with a little background. Estate planning options for the LGBTQ community have come a very long way. Our society has come a very long way, even in the support of this community. Over the past 10 years, human and civil rights activists have fought hard for marriage and equality and inclusion. So when an LGBTQ couple enters into marriage as defined by the state and licensed by the state where they live, those benefits of marriage under state law extends to that couple, which is huge because before that, they were not considered, they were not extended the same rights that married couples were extended, and those rights are very favorable, and we'll get into that as we go on today. So because we do estate planning, we like to navigate end-of-life decisions. And how does your life continue from the standpoint of the transfer of your assets and decisions that you want to make at the end of life? And most importantly, for today's topic, how does that impact your partner? And so today we're going to focus on a couple areas of the estate planning process. So let's kind of talk about our agenda for today. Our agenda is to talk a little bit about wills and trusts, powers of attorney, healthcare directives, avoiding probate, actually what is probate and avoiding it, and then final arrangements. So let's kind of jump right in and cover each one of these topics. First, let's start with the simple premise that a plan is better than no plan. Whether you and your partner are married or whether you're married or not, having a plan is better than no plan. And so we're going to start now with the premise being that a plan is designed with a minimum of a will and is probably best designed with some form of trust. So when we plan with a will, at least we're documenting our last wishes. We're saying I want, my assets to be transferred to these people or these charities or both, and I want this person in charge. Now, that's good, but what's better than that is when we do a trust. And the reason I like a trust when working in the LGBTQ community is because a trust creates a level of completeness that a will cannot achieve on its own. Let me explain. A will by its very nature needs to go to probate whenever the person who dies assets exceed $100,000. Now, I'm simplifying that for the purposes of today's discussion, because as you know, for every rule, there's an exception to a rule. But as the general rule goes, if you have a will and you have assets that exceed $100,000, then that will needs to go to probate. Now, probate is a court proceeding where a judge takes your will, looks at it, says, yes, this appears to be the valid will of the person who has died, and they admit it to the probate court, which means now the probate court has jurisdiction over that will and is in charge of administering what it says. That sounds good, but it comes with a few pitfalls. The first one is it's very expensive. The average cost of probate in our area can be between $10,000 and $18,000, depending on the sophistication of the estate, and it can certainly exceed that as well. There's no good system in place for dealing with minor children, and often couples will have children, whether adopted or otherwise, and those children, if they're minors, there's no good system in place through the probate court to deal with the money for those minors that is efficient and cost effective. And I'll get into some of those details as we move into the trust, and I'll contrast those. Very time consuming. So probate can last up to, well, it can last a very long time actually, but at a minimum, it typically takes 12 to 14 months from the time that the person passed away. And we've often seen that time frame go much longer. This is the one thing, then my next point is the one that concerns me the most, and that is the final wishes of the decedent, that could be you. Those final wishes can be challenged in probate court, meaning that somebody who does not agree with the lifestyle, a family member, can not only challenge your final disposition of your assets, but can also challenge who the executor is that you named in your will. Now, I will tell you that, as I mentioned at the beginning, if you are married under the laws of the state that you live in, the license afforded you through marriage will give your partner greater protection from these kind of challenges. But if you're not married or your state doesn't permit marriage, then this challenge is even a greater risk. Finally, one of the reasons that we like to avoid probate is because all of this is handled in our court system, which is a public forum. And listen, doesn't matter what community you're in, whether you're, having all of your life aired out in a public forum, especially when people are contesting what it is that you left for your final disposition, is just unsettling for the family. And we don't want to have to put your family through that exercise. So let's talk about why for the LGBTQ community, a trust is a better vehicle. Number one, and this is by far, I think, very important, it is private. So when you do a trust, you set forth exactly who you want to be in control when you can't do it. It sets forth the final disposition of your estate assets. And only people who have an interest in your trust, not somebody who finds your trust interesting, but somebody who has a legal interest in your trust. This would be a beneficiary. This would be a trustee. These people are the only people entitled to information in your trust. So if you did not name somebody as a successor trustee or as a beneficiary under the terms of your trust, then the trust terms can remain concealed to those people who are not vested in your trust. It's not contestable. So we talked about the will and the fact that the will can be contested. And now, when I say a trust cannot be contested, there are certain instances where it can, but not in the traditional sense that most people think of. I like to say this: when you do a trust, your final word is your word. Nobody is going to step in and try and modify or change or somehow circumvent the purposes and your intentions that were created when you created this trust, which should be a very good feeling. You should feel as if, good, this was my life, these were my assets, and so as a result, when I die, I want to say who's in charge and to whom they go to. A trust, by its very nature, avoids probate. So the reason we're using the trust is because we avoid all of those elements that I had set forth that were a problem with the probate process. A trust is simple to administer, and simple means inexpensive to administer. Remember when I was talking about the will and the fact that we went to probate, that it was going to take 12 to 14 months at a minimum and could cost anywhere from $10,000 to $18,000 or more. All of that gets thrown out the window when we talk about administering a typical basic living trust. It's usually $1,000, couple $1,000 to administer, sometimes a lot less. And it's very quick. Most trust administrations for the average family of a couple $1 million, $2 or $3 million net worth or less, the average administration time can be a couple months. A trust is also extremely customizable, meaning if you have thoughts about taking care of pets, taking care of children, taking care of loved ones or charities, and various complexities in your mind of the nuances of how you want your assets distributed and divided up and under what circumstances, are all permissible under a trust, which makes a trust a very flexible instrument. Also, I touched upon minor children. Minor children, when they become adults at age 18 or 21, we all know are still children from an economic maturity level. It's only when we get to, I don't even know the age, honestly, but as we get older, our maturity increases with regard to how we manage and view money. And so having a trust gives us the tool to plan accordingly and devise a system of payouts so that children between the ages of, say, 18 and 40 have specific markers defined which help them manage money that they may inherit during those ages, thereby doing two things: protecting the child from their maturity level and protecting their assets for them while they are learning the value of money. Now, I mentioned that many states, if not all, have approved marriage in the LGBTQ community. And that is great because that license of marriage afforded by the state gives you many rights that otherwise didn't exist. But I will say this: while I have no insight into what I'm about to say from a prediction standpoint, I think it's fair to say that our country seems like it's a bit unstable. And so when we live in a time where things are very uncertain, I get very concerned about the laws of our country. And so I would suggest that the fact that marriage exists today in this community should not be 100% relied upon, that law can't change. We've seen it change a couple of times just in the past couple generations. And so whether you're afforded the privileges of marriage or not, having a trust circumvents the concern of whether or not those laws will exist in the future. Also, when you plan appropriately for your death and your estate, you're taking care of those things that really matter. Because I have seen way too often a partner comes into my office after their partner has passed away and they did not plan. And when there's no plan, we often see family members come into the picture who were not supportive of the relationship and try to undo what was discussed between you and your partner. And that is a terrible situation because you have spent your life with this person, invested everything with them, and now a family member who did not support your decisions is coming in and railroading the person that you spent your life with. We want to preserve the relationship that you had developed even after death from the standpoint of the things that you discussed and your wishes are upheld. So that's a brief overview of wills and trusts and why every couple should do some form of planning. And I'm encouraging trust planning for every couple because of the reasons that I set forth just previously. Now let's move on to powers of attorney. Again, very important. And there's two types that we're going to talk about: power of attorney for property and power of attorney for healthcare. Also, the healthcares are called healthcare directives. These documents are used when you lose cognitive ability or become disabled. So you develop dementia, or you're in an accident where you lose your cognitive ability, or you have a stroke where you can't think or manage your affairs as normal. There's numerous examples we could give where you no longer can manage your finances or good healthcare decisions. Now, if powers of attorney are not put in place, this leaves the door open for a process in our state called guardianship, and in other states are called conservatorship. And if you would know a little bit about both of these topics if you watched my last episode on Britney Spears and all she went through with her father and the conservatorship / guardianship. But that's a topic for last time's video. We put powers of attorney in place so that your partner can make good decisions for taking care of your finances and good decisions to take care of you in the event you can't take care of yourself. Who's going to be in charge? Is a non-supportive family member going to enter into the picture and try and take charge of your life because of your incapacity? Or are you going to make the decision and define it on paper who's going to be in charge of managing your affairs? Also, when do these powers of attorney become effective? You know, the question of when it becomes effective often is defined by the age of the couple. Couples that are in their later years of life, and I define that as late 70s, 80s, and above, we like to have property powers of attorney and healthcare directives effective when they're signed. This gives both partners equal access to work with one another through those years when people are starting to slow down a bit. Younger couples, we like to put these documents together in a way that they called spring into effect, which means they're not effective when they're signed, but rather they spring into action when you lose your cognitive ability. And so you should have a property power of attorney and a healthcare power of attorney to protect you, and so you define who's in charge and who's making decisions and what the scope is of the decisions that are being made. The point of the healthcare and the property power of attorney is for you to define whose input is being listened to when it comes to your healthcare and the management of your finances. So our next topic is avoiding probate. And I just kind of feel like I've beat this horse pretty good. By the way, I don't beat horses, but you kind of get what I was saying. Anyway, but let's recap, shall we? Probate is very expensive. It doesn't have simplicity when planning for minor children. It's very time consuming. It can be challenged. And when I say challenged, it gets challenged not only towards what your final disposition wishes are, but also who can be in charge. So who your executor is can be challenged. And it's public, meaning that all of this nonsense is being aired out in the court system of the county where you passed away. So avoiding probate is paramount in my mind for, everybody, but it is especially important in the LGBTQ community, where oftentimes there is unsupportive people in your family who would like to do nothing more than disrupt the happy family that you've put together because they don't support the lifestyle you've created. And so by planning appropriately and avoiding probate, we can ensure that your final wishes are met. And then final arrangements is our last topic for today. And your final arrangements are, so personal, so amazingly personal. And wouldn't you want your final arrangements made by the person that you've spent the most time with? That the person that you've discussed these very difficult topics with? Excuse me. Your final arrangements are very important. We need to know, where are the final arrangements going to be made? How is the disposition of your remains going to be dealt with? And with whom is invited to partake in this very important time? And so defining your final arrangements and putting them in writing is so personal and so important that in the planning process, we can help you put together the plan so that when the time comes, the way you and your partner foresaw it to happen is the way that it happens. So now let's just do a real quick recap for those that are just joining us. My name is Christopher Nudo. I'm the founding partner of an estate planning law firm and real estate law firm in the Chicago metro area. We have offices in Arlington Heights, Elgin, and now brand new by appointment only, Bannockburn, Illinois. And we serve all communities. And today we are focused on the LGBTQ community. We help professionals, parents, neighbors, just literally everybody with their legacy planning. Legacy planning is a great word for helping you plan for how your life is perpetuated even after death. In this week's Facebook Live, I've taken the time to talk about estate planning considerations for the LGBTQ community. And last session, if you missed it, you should go back and watch it. That's where I discussed what is a conservatorship and explaining the Britney Spears documentary, which, by the way, I found absolutely fascinating. If that interests you in any way, please go to my Facebook page and give it a watch. We'd like to welcome you to join us here every Friday, 8 a.m. Central. Well, I don't know if that's really true. I was here at 7:30 Central, so my notes and what I'm actually doing conflict. So it's pretty much every other Friday, 7:30 Central time, where I'm going to share different legal tips and guidance for parents, guardians, and other professionals. Now, I'm so excited with the number of you that have joined us here this morning. You've given us a bunch of questions. I'm going to quickly go through the questions that I see and give us some answers. We're going to wrap up and we'll be out of here. So, Question number 1 that came in. How can I ensure that my wishes are carried out if I have unsupportive family members? Oh, what a fantastic question. And this really burdens me. And so that's why I even brought much of this up earlier in our discussion. To unsupportive family members love to disrupt your partner and your wishes if the estate is not planned properly. So sitting down with me or any good estate planning lawyer and discussing exactly how you want your estate to go when you pass, and then using the tools that we have, which 90% of the time is going to be some form of trust documentation, will ensure that an unsupportive family member does not disrupt the most tragic time in the life of you and your partner. Great question, and thank you. Second question. If we were married before, how can we amend or remove a previous spouse from an estate planning document? This is so important, and thank you for that question. When your partner changes, or if you are married before and you go through a divorce, and you have estate planning documents that were designed in your previous relationship, it is imperative that you stop what you're doing, don't pass go, don't collect $200, immediately contact a supportive estate planning attorney who will sit down with you and your partner, look at the documents you have, amend them or revoke them and do new documents, whatever is appropriate, so that if you pass away, your wishes are upheld under your current circumstances, and an unintended result does not come about because you forgot to amend your previous estate planning documents. Third question. Is there a certain amount of wealth or assets required for setting up a trust? All right. The answer is yes. Theoretically, the cost of setting up a trust should be commensurate with the goals that you're trying to achieve. But I don't like to always just focus on the dollars, because minor children play into this. The fact that you are a same-sex couple plays into this significantly. And so I don't like to focus on the dollars, but the dollars do affect the equation. And it's not possible for me to set forth what that dollar amount is. It's dependent on our conversation and what we're trying to accomplish. But please know that we're going to try and do some form of trust planning, because we want to ensure that nobody interferes with your plan and that your plan is well executed, especially if you have children that are younger in age. Next question. Oh, a question about children. I love this one. I am worried that my family will try to take custody of our non-biological children. How can I plan for that possible situation? Excellent question. The answer is a will, is a trust with an accompanying pour-over will. When we plan appropriately and name guardians in a trust and a will, we are doing the best we can to avoid interference, outside interference, if you should die. Obviously, the adoption process will secure the relationships between non-biological children and their adoptive parents. But we also like to take the time to articulate these wishes inside our estate planning documents. This way, it minimizes the chance of interference. Next question, can my family override my partner's decision related to my health or finances? The answer is yes, if we don't plan appropriately. This question goes directly to the healthcare power of attorney and the property power of attorney. We want those two documents in place so that if you are incapacitated and lose cognitive ability to make good decisions for yourself, that your partner has the full authority, assuming that's what you want, and a family member cannot step in and usurp your partner's authority in some fashion, thereby redirecting assets or healthcare decisions that otherwise you do not support. Our next question. What legal rights will my partner have if my family tries to intervene while I'm incapacitated? Well, I think we just touched on that. The interference of family members is a real thing, especially if they're unsupportive family members. I see all the time, everybody thinks they're doing what they think should be done, and they think they're making the right decisions. The problem is this. You are the person who should be dictating who makes decisions on your behalf. And so by putting healthcare directives, powers of attorney for property, living trusts, and its accompanying pour-over will, by putting these documents and others in place, you end up making the final decision on who is in charge, where your assets go, and if you are incapacitated, who is making those valuable, value-based decisions on your behalf. Okay. This question not related to our topic today, but do I offer virtual appointments or on-site visits? And the answer is yes. I offer both. I prefer on-site visits. I think looking at each other in the eye and sitting across a table is an easier way to communicate. We're all inundated today with virtual meetings. And so the virtual meeting is, if we can get away with it and have some human interaction, it's preferred. But for sure, if geographically it makes more sense for us to meet virtually, or if because of timing we can't meet, absolutely. Let's set up a Zoom or a Google Meets or a team meeting, whatever it takes, so that I can help you, or I can help you plan appropriately. Where can I contact you to set up a consultation? Well, okay, right at the bottom of the screen here, we have phone numbers that you can call and text. And that's honestly the fastest, most efficient way to get a hold of our team. One of our fantastic team members, Stephanie or Amy or Martell or Anthony or even me on occasion, are standing ready and willing to answer the phone, answer your questions, and help you get set up with a consultation with us. Well, that's all I have for us today, and I really want to thank you for joining us. I cherish this opportunity to earn your trust and to work with you and your partner to plan for the future so that all that you guys have put together between yourselves can live in a legacy format when one of you passes away. And like anything, proper estate planning is a process, and it takes a little bit of time. So I encourage you not to procrastinate this, but to reach out to us, and let's start that discussion now. It would be a pleasure for me to sit with you and to review the goals of your family. I invite you to join us here again for our next Facebook Live, which is Fridays at 7:30 Central Time. Please, there's no greater privilege than if you invite your family and friends, and feel free to share this recording. It'll be posted up on Facebook and on my website, and feel free to share it with family, friends, colleagues, and I hope to see you here again. Stay well. God bless.